It's always wonderful to be back in Berkeley. One learns a lot here, and not always from the expected sources. When I landed at SFO a couple of days ago, I then, in an unusual moment of public spiritedness, took BART. And when I arrived in downtown Berkeley, summoned the ubiquitous Uber, and as I was traveling to where I was going to be staying, I realized I was coming from Philadelphia that my overcoat was stuck in the door. And so I opened the door slightly to pull in my coat, and suddenly I heard someone yelling at me, "Don't ever do that again." It was a bicyclist who was threatened by my opening the door, and I said, not missing a beat, "I promise I'll never do it again." Life in Philadelphia, strangely, is more relaxed than I found Berkeley. The life of the law, Oliver Wendell Holmes Jr. famously wrote in the first sentence of his magisterial book, The Common Law, has not been logic, it has been experience. Holmes's target was the formalism in law then in vogue in the United States, according to which the practice of law ought asymptotically to approach the method of geometry. Holmes's criticism should, to a point, be well taken, though today no educated person would need to talked out of the misunderstanding of law in more geometrico. My interest here, therefore, is what lurks in the other horn of the false dilemma propounded by Holmes: experience. Having delivered law from the dead hand of geometry, Holmes, by a sleight of hand, reduced life's law to mere experience. In law, as in the rest of human living, experience is ordinarily only just a beginning. And this, I think, is the crucial point to be unpacked. In the rest of human living, we experience, we understand, we judge, and we decide. And sometimes, I'm obviously tracking Lonergan here, we fall in love. We wonder, we ask questions, we answer the questions, and we reach judgments, which in some parts of life are certain, but in practical affairs are usually only probable. We experience, we understand, we judge, decide, and if we're able, we fall in love. What I've just provided in the worst summary form is not a metaphysics, not an epistemology, but, if you will excuse the term, a gnoseology. This unfamiliar but well-attested, if uncouth word, refers to an account of what it is that we are doing, the operations we are performing when we are knowing. A metaphysics offers an account of what is, and epistemology offers an account of the necessary and sufficient conditions of human knowing, and a gnoseology states what it is that humans are doing when they are knowing. As an aside, but more than an aside, we do well to note that the reason gnoseologies are so rare is that, as Lonergan observed, human intelligence, intellectus, as it used to be called, is often treated as a black box, the interior life, if it has one, of which is not available for inspection even to the person whose intellectus it is. To rest content with experience as an exhaustive alternative to logic is just one clear and proximate example of how human understanding gets left out of the picture of what humans can and should do. Returning then to my theme, I can anticipate any number of objections to the gnoseology I've proffered in summary form, and I would welcome a further opportunity on another occasion to meet them. My present point, however, is this, and I conceive it to be beyond dispute. Whatever knowings we achieve in law are the product of whatever operations humans perform whenever they do any kind of knowing whatsoever. Knowing in law, in other words, is neither exempt from nor an epistemically privileged form of the cognitive operations, the proper performance of which leads to whatever knowings humans achieve. None of this is to suggest that law is not what we might call a particular specialized instance of the basic pattern of human knowing. On the contrary, law does indeed have its own characteristic and malleable methods and modes, each and all of which can and should be evaluated for their merits in harnessing the method of human understanding itself for the achievement of the ends or goals that are the proper domain of law. What practitioners of law cannot do, except at law's peril, is to proceed or purport to proceed according to methods or modes that are not isomorphic with the method of human understanding itself. The substitution of mere experience for knowing would assure just such peril. Which brings me back to Holmes, whom I'd like to use briefly as a test case by which to unpack further how practitioners of law achieve law. The same Holmes who had assigned the life of the law to mere experience was later the author of the Supreme Court's opinion in Buck against Bell, the case that upheld against constitutional challenge a Virginia statute permitting the compulsory sterilization of those who, now in Holmes's words for the court, are, quote, manifestly unfit from continuing their kind, close quote. Holmes's opinion for 8 members of a 9-member court ran a mere 5 paragraphs, leading one legal scholar to observe recently that the opinions Holmes wrote achieves, quote, the highest ratio of injustice per word ever signed on to by 8 justices of the Supreme Court, progressives and conservatives alike. Only one justice, Pierce Butler, filed a dissent, about which more momentarily. Proceeding from whether it amounted to injustice or not, I think the answer is clear, the question remains, on what basis did Holmes, acting as a justice of the Supreme Court of the United States of America, reach this bracing, one might even be inclined to say barbaric, conclusion in the name of the law? Here, with nothing of substance elided, is what Holmes wrote for the court. Quote, we have seen more than once that the public welfare may call upon the best citizens for their lives. Holmes had been severely injured fighting in the Civil War. It would be strange if it could not call upon those who already sap the strength of the state for these lesser sacrifices, often not felt to be such by those concerned, in order to prevent our being swamped by incompetence. It is better for all the world if, instead of waiting to execute degenerate offspring for crime or to let them starve for their imbecility, society can prevent those who are manifestly unfit from continuing their kind. And now to the clincher. Quote, the principle that sustains compulsory vaccination is broad enough to cover cutting the fallopian tubes. 3 generations of imbeciles are enough, close quote. And with that, the opinion rested, except for brief anticipation of a counter-argument about which I'll say nothing. Most among us are repelled by the result in Buck and by the court's language in defense of it. But from repulsion, it does not follow that the decision was wrong as a matter of law. What then was the legal problem, if any, vitiating or at least compromising the majority's decision in Buck against Bell? A juxtaposing of 2 thoughts Holmes shared with his friends concerning the decision in the case will provide the beginnings of an answer. The first, written while the case was pending, quote, Butler, Justice Pierce Butler, knows this is good law. I wonder whether he will have the courage to vote with us despite his religion. Butler was a Catholic, the only Catholic on the court at the time who is reputed to have gone to Mass daily. The second, written to Harold Lasky immediately after the case was decided, quote, I wrote and delivered a decision upholding the constitutionality of a state law sterilizing infants, sick, the other day, and felt that I was getting near to the first principle of real reform. Close quote. As to the latter, Holmes's getting near to the first principle of real reform was emphatically not a matter of what we call today pejoratively judicial activism, and for this reason it cannot be dispatched to one of the usual pigeonholes of superficial analysis. After all, at least from one point of view, Holmes and his 7 brethren, who joined the opinion did neither more nor less than read the Constitution of the United States and conclude that it did not require nor even allow refusing effect to the Virginia statute. On this view, the legislators of Virginia were the reformers, which assuredly they were, while the Supreme Court, including Holmes, were not reformers at all, but rather mere rule followers. Followers of the rule that statutes that do not offend against the Constitution must be given effect despite any moral repugnance they might engender. From another point of view, however, the court was doing far more than the rule-following model excuse suggests. Specifically, the court was choosing among several legally available options when it chose to conclude that the Constitution provided no legal impediment to the reform wrought by the Virginia statute. The justices who found or rendered the Constitution itself impotent in the face of a compulsory sterilization statute knew perfectly well that other majorities of the same court had in the then recent past found in the Constitution substance calling for the invalidation of reform statutes. The textbook example is, of course, Lochner against New York, the case decided in 1905 that held that the 14th Amendment included a right of contract that rendered unconstitutional New York's limits, statutory limits, on the hours bakers could work. Holmes, however, was not among the justices invalidating the New York statute challenged in Lochner, for which reason Holmes can be credited with, at least, consistency. But consistency fails to capture the jurisprudential commitment at work in Holmes's judging because we can recall, in anticipation of a possible dissent by Justice Butler, Holmes contended that the Virginia compulsory sterilization statute was, quote, good law, close quote. By good law, Holmes surely did not mean that the Virginia statute was valid because it was a demonstrably prudential derivation from the first precept of the natural law, to wit, that the good is to be done and pursued and evil avoided. Holmes had no time for the natural law as it was understood by the Central Western tradition, another point to which I'll return. Holmes, by the way, when it was suggested to him by his friend Monsignor Sheehan that he read Suarez and Dante, said that he couldn't possibly learn anything from either of those. He later did read Dante and claims to have taken something away. It's not known whether he ever read Suarez. What then did Holmes mean by good law? Given what he wrote to Lasky about how he had approached the principle of real reform, as well as what we know from other sources, including the man himself, about his enthusiasm for Darwinism and eugenics, we can be confident that he believed that the statute embodied, while permitting compulsory mutilation of the body, good in the sense of very, very, very useful policy. What Holmes meant by good law, however, because this is how lawyers talk, was exactly that the challenged Virginia statute was valid because it had been enacted in a procedurally proper way by the Virginia legislature and did not violate any constitutional guarantees of the U.S. Constitution, nor, though the issue was not before the court, any guarantees of the Virginia Constitution. In sum, Holmes's lawyerly points about good law were, first, that the statute's pedigree was good, and second, that the pedigree was sufficient for legal validity. Granting for the sake of argument that the pedigree was indeed worthy of one of my favorite movies, Best in Class, was that, in fact, sufficient reason for the court to uphold the statute? Or would the better view be that the court should be understood to possess the authority, as opposed to sheer power, to refuse effect to a statute that, though perfectly pedigreed, is unjust or immoral? The latter line of questioning obviously raises issues of a piece with those we discussed here last year, but now with the tables turned upside down. In the same-sex marriage arena, the court rose to assert judicial authority to strike down as unconstitutional statutes that do not recognize same-sex unions as marriage in law. And let there be no mistake about it. The pedigree of the statutes found unconstitutional in Obergefell was unquestioned because unquestionable. It was the substance that was the asserted defect justifying a finding of unconstitutionality. The question then boils down to this: how can the same Constitution pose no barrier to compulsory sterilization, but deal a fatal blow to restricting marriage to opposite-sex couples? The short answer, of course, is substantive due process, that well-entrenched oxymoron. And also the well-attested but arguably textually unfounded doctrine according to which the courts, on the basis of the due process clauses of the Fifth and 14th Amendments, respectively. Holmes refused to require due substance in Buck against Bell, as he had in the other case to which I alluded, Lochner. But why? Why should someone be so keen on reform refuse to avail himself of an attested judicial authority to invalidate statutes for want of sound substance, as the Lochner majority did? Holmes's self-denying judicial posture in Buck, as in the other cases, had grounding deeper than his contingent preference for the reform results reached by the legislature in the statutes under review. Consider the following vignette provided by Judge Learned Hand, perhaps the most well-remembered American judge who never served on the Supreme Court. I'm quoting Hand now. I remember once I was with Justice Holmes. It was a Saturday when the court was to confer. It was before we had a motor car, and we jogged along in an old coupe. When we got down to the Capitol, I wanted to provoke a response, so as he walked off, I said to him, "Well, sir, goodbye. Do justice." He turned quite sharply, and he said, "Come here, come here." I answered, "Oh, I know, I know." He replied, "That is not my job. My job is to play the game according to the rules." Close quote. Holmes is by no means a sympathetic character, and he is well and deservedly known for arguing that one can best understand the law by wringing out of it one's thought of moral considerations. I nonetheless follow H. Jefferson Powell, professor of law and divinity at Duke, in construing Hand's vignette as a key to unlocking a fundamental jurisprudential commitment on the part of Holmes that is conspicuous, above all, ironically, for its self-abnegation. Holmes told Hand that my job is to play the game according to the rules. Holmes did not attempt to explain the point of the game, nor did he specify the rules that define the game. Instead, according to Powell, quote, he expressed a certain attitude, a moral attitude, toward his place within that practice. Whatever it means to act as a judge, and whatever the point of society giving people that role, as a justice of the Supreme Court, Holmes's job, as he saw it, was to fill the role, to play the game as, I think we can interpolate, this is still Jefferson Powell, people generally understand the game according to the rules generally accepted, close quote. Further explicating what he takes to be Holmes's position, Powell explains, quote, the obligation to remain within the role is itself a moral obligation. Justice Holmes, if this is right, was not denying, but rather insisting on the presence of a moral dimension to the role of the judge, close quote. In sum, the judge does not go beyond his role, not because he does not care about morality, but exactly because he does care. But this, of course, necessarily leads to the question, what are the ethical obligations and commitments of the judicial role under our Constitution? The answer to this question is, again, complex, but Powell's, I think, accurate account of Holmes's understanding of the judicial role, which is, in turn, Powell's own understanding, is this. Constitutional law is intrinsically a moral activity, just as Hand understood Justice Holmes to imply. But the ethical aspect of constitutional decision-making does not lie, at least not proximately, in the decision-maker's conformity to extra-constitutional moral criteria, such as doing justice. The rules by which we play the constitutional game are not external, but, again as Holmes implied, internal to the game. Constitutional law is something we do, not something we have as a consequence of something we do. Powell proceeds over the course of the remainder of the book from which I'm quoting, called Constitutional Conscience, to make as persuasive a case as I've seen for treating constitutional law and the judge's role therein as a matter of playing the particular game that is constitutional law by the rules. To be clear, there's nothing in the nature of a constitutional rule per se that precludes it from allowing or even requiring recourse to sources outside of the constitutional text itself. Even a set of constitutional rules that includes at least one such rule suffers, however, from a terminal defect that I shall call premature closure. The point of a game, in the usual sense of the term, is exhaustively given in the instructions or rules of the game, which, of course, are of human construction. The point of human life, however, is not of human construction, at least not ultimately. The ultimate point of human life is given by nature and by supernature, and moreover, it is not given all at once as an epistemic matter. It is discovered and uncovered in the course of history, or at least it can be. Its discovery and uncovering would be a choice. The choice to treat law as a game of rules imposes a closure that is premature exactly because individuals and their society's obligations to discover and conform to the naturally given point of human life is non-defeasible, or so Christians ought to contend. The alternative view, as Powell observes, emerges from the transfer of sovereignty, as under the U.S. Constitution, from state to the people. The crucial and novel feature of American constitutionalism, according to Powell, was, I think correctly, the separation, correctly as a report, not a normative judgment, was the separation of sovereignty from the state. If the sovereign is distinct from the government, then the instruments of state can be limited in their authority, and the idea of a written constitution becomes possible. Powell continues, quoting Philip Bobbitt, "Thus, in American society, questions of the constitutional structure and powers of the state have become lawyers' questions, and the power of the state, no longer sovereign, has been put under the law, the Constitution, and thus put under the common law forms of argument that were originally and have remained what defines legal argument. Something counts as a constitutional argument. It is a move according to the rules of the game if it takes the form of one of the recognized modalities of common law argument, because they are the grammar of constitutional law, that system of logical constraints that the practices of legal activities have developed in our particular culture." If, as Powell and Bobbitt contend, and I think correctly, constitutional argument, in order to avoid becoming ungrammatical and therefore legally irrelevant, must follow the recognized modalities of common law argument, it does not follow, indeed it's a contradiction of the fundamental presuppositions of the common law, that it is a closed system. A written constitution is indeed susceptible of interpretation according to the common law modalities of argumentation, but the common law modalities of argumentation become something other and less than they were if and when their scope and horizon are, however carefully, limited and capped. Powell defends a closed constitutional universe driven within its delimited ambit by the recognized modalities of common law argument by several contrasts, one of which is that the U.S. Constitution itself requires judges and justices to seek in each case, quote, to reach the outcome that is in fact the humanly best outcome possible in terms of justice, close quote. Notice that this contrasting position posits that the Constitution itself, not, say, the judge's non-textually moored preferences or commitments or ideals, require the humanly best possible outcome. The reason Powell gives for rejecting this as an available interpretation of the Constitution, and thus of exercising the judicial role under our Constitution, is that because, quote, decisions about the best human outcome depend, much of the time, on substantive and highly contestable accounts about what is, in fact, the human good, close quote from Powell. Such decisions should be avoided whenever possible exactly because they sow divisions, so Powell contends, within the republic that the Constitution is meant, think Lincoln, to bind together. Now I quote Powell again. "At least in cases not driven by obstinately precise constitutional text," the president must be at least 35, "the court does not replace mistaken views of the Constitution's goals with correct ones. It merely substitutes the debatable views of a majority of, say, Congress with the equally debatable views of 5 or more justices. That such judgments are and must be made can be taken for granted," says Powell. "That such judgments can be a regular feature of constitutional adjudication by the court is a view that threatens to transform judicial review into a means of partisan dispute." Is this view correct? The preceding question is the very one Powell rules out as possible within constitutional argument that constitutes our republic. Now, I have more text written here, but I don't have time to read it, so I'd just like to touch on a few points by way of conclusion. What I began by arguing is that any knowing in law, if it's to succeed, must be based on a method that is, as I put it, isomorphic with the method of human understanding, both theoretical and practical. Treating texts, even the Constitution, as not susceptible of the common law modes of argument, but instead as simply a set of rules to be followed, it seems to me, has been, and I talked about this last year, our generation's and our culture's attempt to stop what is perceived as cultural decay in its tracks by treating the Constitution, again, as an exhaustive set of rules that are not open in the sense that common law argument was. Justice Scalia once said, mocking the common law as a Mr. Fix-It mentality, that the common law was like playing Scrabble. You couldn't take things away, but you could just add to them. That was the genius of the common law, one step at a time. And as Marianne Glendon has pointed out, herself a student of Lonergan in this as in so many other respects, the method of the common law was what we've known since ancient times as dialectical reason. And what the common law judges did quietly, without much notice, was to engage in dialectical argument. Yes, also using analogies, also using induction and deduction, but above all, engaging in dialectic with a view toward instantiating individual and the common good. So my conclusion is that we live awash in an ocean of law. When law is treated as it is so often in our culture, as exactly what the sovereign posits, legal positivism is the name of this view, law is all and only what the sovereign posits. And therefore, you better write it all down. You need to keep writing laws down because law does not also consist of the first precepts of the natural law clarified by the divine law. So the better understanding of law that I would put forward as an alternative to the obsession with text treated in isolation would be a recovery of the common law mode of argument, now as specifically applied to the Constitution, but more broadly in our legal system. And my final point is that, with all due respect to my friend Dan, legislatures have the peculiar freedom that they don't have to give reasons. Courts have to give reasons. Even administrative agencies, though we love to vilify them, must give reasons if their actions are to survive judicial review. And it seems to me that the common law had built deep into its structure of the judicial opinion a rationality that's lost by the positivists just trying to figure out what the sovereign happened to mean the last time he happened to write something down and didn't have to give any reasons. And so, as one of the great legal scholars of the 20th century said, there are many rooms in the mansion of the law. And I think that the rush on the right, one thinks mostly of Justice Scalia, to petrified texts is a remedy that's worse than the disease. And so as T.S. Eliot said, and Lonergan quotes him to this effect, the only method in the end, prescinding from grace, is intelligence. And it's on that basis that I would urge that we try to root law again rather than in the will of the sovereign. Thank you.